Good evening, everyone. Welcome to the third annual New Jersey Youth Transition Conference. My name is Amy Edley, and I work for Values into Action on behalf of the YTC Planning Committee. This evening's presenter is Christina Schnyer with the Community Health Law Project, presenting on the topic of housing and tenant rights in New Jersey. Christina?
Thank you. Hi, everybody. So I am going to go over a lot of information for housing. So feel free to type questions in the chat along the way, and I'll do the best that I can. Or if I can't get to them right away, I'll try to review them at the end so that we can all be on the same page, because a lot of this is complex and very detail oriented. So if something's not clear, I do want to try to do my best to look at this stuff along the way to make sure that I'm understanding if it's not clear. So thank you for your patience and attention, and I'll try to get through this as it's a lot of information. So you'll see that my co-presenter, Sean, is not here today, but I still have his information as well on here in case anybody has any questions. You can reach us at our office. The information will be at the end. If you do need any sort of legal advice, we can see about eligibility and go from there. But
Christina, I'm sorry to interrupt you. I just want you to let you know we can see your next slide and it's not in presenter view.
Okay. That is interesting. Let me see.
Well,
sorry, I have a split. Okay, that's fixed. Okay, so again, so the agenda for today is to, again, first off, housing is a basic human right. It is one of the most important things that you can do to maintain your health. That's why the system of medical legal partnerships has really become kind of an area of growth in our society and in the legal and medical world, because of the recognition of how crucial health and housing are and how interrelated they are. So from there, we're going to be talking more about tenants' rights, specifically in New Jersey, evictions, and some of the defenses to getting evicted. And then we'll be talking about subsidized housing, vouchers, and different forms of rental assistance. So just a little bit about our agency. We are a nonprofit, and we do help people across the state of New Jersey with disabilities, whether that's physical health, mental health, developmental disabilities, hearing, visual impairments, and so on and so forth. So housing is just one of the areas that we cover. We do cover a lot of different areas, as you can see here. But if you have any questions about anything, as I mentioned before, I'm going to have some of the information for our offices at the end. Well, for our office specifically, the one in Elizabeth, but then also after this, I'm going to have all the offices in case you need to contact us. But everything that we're going to say for tonight is just kind of a brief overview of the law. It's not specific legal advice. So if you did want specific advice, you can see these phone numbers here and give us a call for possible legal assistance. But to get going, so as I said, housing is a human right. It's in the New Jersey Anti-Eviction Act that most tenants, maybe not all, but many tenants are covered in the state of New Jersey with specific legal protections to maintain that right. So the Anti-Eviction Act covers tenants in houses, buildings, mobile homes, rooming homes, boarding homes, but there are certain tenants that are exempt. So to start, some of the exemptions, as you can see, are homes that are owner occupied that have only 2 rental units. So if there's an owner and 2 units, then you cannot fall under the Anti-Eviction Act's protections. So some of what we're going to talk about next, a majority of it is going to be about the Anti-Eviction Act and those protections. Besides that, if this house does have a couple of units, only 3, 2, whatever, If it's not owner occupied though, at the moment that a case is filed in the court, then if there's no owner in the building, it is still protected under these Anti-Eviction Act rules. So hotels, motels, for example, some of these places that are covered maybe by a welfare voucher on an emergency basis, sometimes people are paying on their own temporarily in between different housing, that would not be covered by the Anti-Eviction Act. So as these legal protections are meant to do, protect, you have to have an actual reason, or what's called good cause, to evict a tenant. So there are a bunch of different reasons. Non-payment of rent is the most common reason that I see. However, there are many times where it's not just an issue of the tenant not paying the rent. Sometimes there are allegations of the tenant being disorderly, and what that could mean, it could be something as simple as littering frequently and smoking, or something as intense as, violence. So it's a wide range of what counts as disorderly, and there's different things to consider. Destruction of property, personal occupancy, but all of these different things require some sort of notice. Non-payment, however, you can simply move forth on that in most cases without prior notice, but we'll get to that in a bit. So the first notice that you would need would be called a notice to cease. However, as you'll see in a second, there are some cases there you don't need a notice to cease, and you'll just get a notice to quit, or no notice. So the disorderly conduct, as I mentioned before, that would be an area where you get a notice to cease, along with some of these other areas listed here. So the point of the notice to cease is to kind of give you a warning, to help you understand as the tenant, or to help the tenant understand, if you're from an agency here tonight, what exactly is they're doing wrong. So if I'm sitting here and I'm, smoking on the front porch, but I don't know that it's wrong and I don't know it's against the rules, the landlord should send me as the tenant a warning saying, hey, you can't do this. This is what you're doing. And these notices have to be very specific. They have to say, for example, you were on the front porch on the 10th of October smoking a cigarette. You can't do this, you have to stop. And it has to say notice to cease, and it's very detail oriented. So these notices are very tricky, and can often be wrong. That would be something that frequently is a reason for a case to be dismissed, or for us to kind of negotiate and talk with the landlord's attorneys to say, hey, you didn't do this right the first time. Let's settle this case, because if you bring it to a judge, you might be told that you don't have a case and it's going to be dismissed. So bringing, really investigating these notices and looking at them carefully to make sure that they follow the rules is kind of the first thing that I would do. And if you don't provide proper notices, as I said, that is the whole point of looking at them carefully, because they can be a defense, causing the case to be dismissed. So after the notice to cease, and then sometimes the second notice to quit is sent, that's when the complaint is what it's called, or a summons, can be filed with the landlord tenant court. It's called the special civil part. So the complaint also has to be very specific. If it's non-payment, you have to say what months are owed, what rent is owed, specifically the amount. You have to also list if there is a rental subsidy in place, for example, Section 8, the most common one. And you also now have to file as a landlord what's called an LCIS. It's a case information statement for landlords. Tenants also have to file one called the TCIS, the tenant case information statement. And that would have information in response, stating if they have rental assistance, if they have whether that's a subsidy, whether that's they're applying for rental assistance for back rent. You'd give all that information in response to receiving the complaint. So you receive it in the mail, and then once you receive that, you can call up the court, get information about a court date, get the information from online about filing a TCIS. And if you do need an adjournment, request that as soon as possible. up to 5 days before is the preference, but sometimes if you're very diligent about calling the court sooner, you can get the adjournment. If you have a doctor's appointment, if the tenant has some prior commitment that prevents them from being there on that date that's scheduled, you have to let the court know. If you get to court, you can go before a mediator. You should go before a mediator to try to settle the case. I do it in every single one of my cases. If there's an attorney on the other side, I still try to sometimes work it out with the attorney. And if we can't, still have a mediator come involved, because they're a third party. They don't work for the judge. They're just a third party with the court to try to help you settle the case. So if you can settle, you'll sign an agreement and either to stay or to go. And you have to be very careful about if you're signing the agreement to stay, the agreement to leave, and what it says in the agreement is going to be very important. For example, one thing that I've seen a lot lately is an agreement with a tenant that was unrepresented and a landlord that was represented by an attorney. And it will say something along the lines of the landlord will help fill out the paperwork needed for the rental assistance. But if it's not received within the month, the tenant's going to leave. But the problem with that is the landlord's attorneys know that a month is not enough time to get this rental assistance for back payments of rent. So from the start, it's kind of not something that is ever really, all they have to do is fill it out. Then that's not really going to mean that, and we have to wait for the process to continue on to see if there's an approval or denial of the rental assistance. So the language of how you settle things is going to be very important, which again is why I always recommend try to get an attorney if you can, or at least really think about what you're going to be writing into this if you're not able to get one. So when it comes to settlements, you want to make sure that you know exactly how much you owe and that what you believe you owe, the landlord is saying you owe. That's where a lot of the disagreements come in. If it's a non-payment issue, you want to make sure you know that, and that if you're agreeing to pay by, for example, the 5th, that payment can be made by the 5th. If you think, well, I get paid on the 5th and I'm going to pay my rent on the 5th, and maybe I'll have enough to pay by the 5th every month, this extra $200. If you're thinking maybe, then don't agree to the 5th. Agree to a later date, maybe the 15th, maybe the 20th, but time it based on if you're receiving SSI, maybe the 5th will be fine. If you're receiving, if you have employment and that you want to base it on paychecks, think about that, but make sure that whatever you're doing, that you're going to save your money to pay, because if you don't pay as part of your settlement, you can risk eviction. So that's most important, is making sure you can pay. And if, as I said, even one payment is missed, the landlord at that point can go to the court and ask for what's called the warrant of removal. The warrant of removal we'll talk about later, but essentially that is what gets the court to evict the tenant. But we'll go more into that later. So if settlement doesn't resolve anything and you want to wait for the judge, you have to wait all day sometimes, prepare to be there until 4:30 p.m. or even later sometimes. Until the judge says you can go, you cannot leave. If you leave, your case will be heard without you. And if you're not there, the case will automatically default into the landlord's favor, potentially, as long as they can prove their basic information, that they own the property and stuff like that. You risk that just being automatically for the landlord. So everything's scheduled in person right now, but if needed, you could request a reasonable accommodation with the court. Also call the court about that in advance if possible. And they are considering requests for virtual appearances. Not every county is going to give that, but many of them are. So the landlord tenant court also, the judge can only either do one of two things. One, they can issue the judgment of possession. That's what gives the landlord the ability to get the property back. Or they can dismiss the case and say, okay, tenant, you can remain in the property. They can't negotiate with you. They can't create settlements of, hey, well, maybe you should pay the landlord some of your 4,000, you know, you can pay this on the first of this month, this is the first of the second month. They can't do any of that. Either the landlord gets it or the tenant gets the property. That's all in a non-payment case that the landlord can decide. That's all in any landlord-tenant case that they can decide. If you want to negotiate paying back in order to remain in the property, you have to do that in a settlement. If the landlord does want the money and they win the case, they would have to go after the money in a separate case. If there is any money that's owed, if there's no money owed because it's just an issue of, you know, the tenant was being alleged to be disorderly or some other misconduct, then there's no money. But if the landlord wants money, they have to file another court complaint and another type of case called a DC case. Okay. So you can, as I mentioned before, get adjournments for rental assistance applications that are pending. It is up to the judge to decide that. The only times I've seen judges recently be willing to approve it is if you have very clear proof of not just a pending rental assistance application anywhere. If it's with DCA and the judges kind of know that there might not be funding right now, they're not going to approve it just because it's pending. They need to know that it's with an agency that has funds, or even more importantly, if they're actually actively considering the application, getting the agency to write some sort of letter on your behalf saying we are processing this application to see if this tenant can receive our funds, kind of helps indicate to the judge that there are funds out there, that they're still actively considering this. And if it's a recent letter, that'll be important. So any proof you can get, ask for a letter from the agency and get it signed, you know, and before you're requesting your adjournment request, bring that before the court. So when it comes to evictions, assuming that there is a trial, after that trial, if the landlord did receive the judgment of possession, that's what gives them the right to have the property back from the tenant, to get it back. 3 days after that, they can apply for the warrant of removal. Or in that 3 days, if you were a non-payment case, you did not pay, and you're able to come up with the money, you take those 3 days to find a way to find the money, and you pay it into the court. So you go to the court with your money and pay the court your money. That's the only way for a non-payment case that you kind of have a 3-day wiggle room. But after that, if the landlord's able to apply for their warrant of removal, if it was a non-payment case or another type of case in which the court decided that the tenant must leave, then the warrant of removal can be issued. The sheriff's officers will come to the door, they'll serve the warrant of removal, knock, 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 post it on the door, and then you'll have 3 business days before you have to leave. They will come back and they will lock the tenants out at that point. So. Slideshow is not going forward. Give me a moment. Okay. So after the warrant of removal is served, if there are other issues that the tenant feels the warrant of removal was wrong, and before the sheriffs come back to lock you out, there are a couple different things you can do. Number one, what's called an order for orderly removal. The court can give you up to 7 days to vacate the unit if you're saying, hey, I just need more time. You know, maybe, for example, I am going to be in this next unit, but it's not quite yet. I just need a bit more time, you know, to get into the next unit. It's a week away. Sometimes the judge will issue an order for orderly removal for 7 days to get into another apartment. If you need even more time beyond that, you have to request a hardship stay. But importantly, you have to be able, as the tenant, to pay moving forward. If the tenant cannot pay every month moving forward, you can't get the hardship stay. So that's important. And it's typically up to 6 months. Using, for example, a tenant who has a voucher and doesn't have the ability to find housing at this point, because of limitations of the voucher, that would be a reason to go before a judge and ask for a hardship stay. There's also a motion to vacate the judgment. So the motion to vacate the judgment would get rid of that original judgment of possession. So the original decision of the judge. So maybe if there was a mistake or something that the judge should not have issued this decision, then you can ask for the motion to vacate. Sometimes before that warrant of removal is concerned, it's also called an order to show cause. So if you get just the judgment of possession, you can get an order to show cause and kind of urgently go into the court. Typically with the warrant of removal, but sometimes you can do it before, and you can ask the court to consider to reinstate the case so that you have the ability to have that trial if you didn't have that trial before. So you have to be able to prove that there would have been that high potential of success, that, you know, here are my reasons where I would have actually won this case, Your Honor. This is what I would have said if I had the opportunity to have a trial. And I couldn't attend the trial because I was in the hospital, and you bring your proof, or because I didn't actually know about this trial, or whatever some of the reasons are. There's a couple other things you have to consider as well, but those are some of the most, you know, basic things that are going to be more important to bring documentation of and proof. So only a judge can decide if the tenant can be evicted. That's, if you're going to leave here knowing anything today, you must know landlords cannot decide to kick somebody out. If a landlord says, you know, these are my reasons I want this tenant out, that's nice. And I'm really sorry to say to any landlords who might not like to hear this, but that does not mean that the tenant has to leave. The only person that can tell the tenant to leave is the judge. The judge is the only person who can decide this. Very crystal clear. So if a landlord tries to go in and change the locks, put wood on the doors with nails and bar over the door, tries to shut off the utilities, starts harassing the tenant even in some cases, and starts repeatedly saying, you have to leave, you have to leave, you have to leave, harassing them. And these things could be considered a self-help lockout. And so immediately you got to call the police, call an attorney, and try to get into the court and ask to be let back into the home or the unit. The sheriff is the only person that can actually change those locks themselves. And the judge is the only person that can say the locks can be changed by the sheriff officer. So anybody else, against the law. So during COVID, there was some issues about, oh, maybe there aren't evictions, maybe there are, but this is done at this point. There are evictions at this point. If some money that was owed from before, this is some of the information from before, I'll go over it quickly. So from March 2020 to December 2021, a tenant could have the ability to get some of this rent that they may have owed forgiven just for that time period. Anything before or after, if they didn't meet the standards listed here, which means that they were no more than 80% of the area median income, and they certify to that income online on DCA's website. There is what's called the DCA certification they can fill out about COVID-19. They had to have the inability to pay rent due to COVID-19, and they also had to have applied for state, county, or some sort of local rental assistance to get paid back for that rent. So if you certified to all these things for that time frame, then you can get protections for anything owed during that time only, March 2020 to December 31st, 2021. There are some people that it goes until August of 2021, and then there's a little bit extra for December 2021. But anything after that, starting January, or even from before, like January, February, March of 2020, well, not March, but January, February 2020 or before, you definitely owe that as a tenant. After, you definitely owe that as a tenant. There are no COVID-19 protections for that. Whether there's other protections under the law, other defenses that you can bring up is a different question. But anything during that covered period is still a debt though. And so you can see, and you will see landlords going after that old debt. They can't kick you out for it, but they can still try to get the money back from that time. So Social Security benefits may be judgment proof. SSI is, SSD is as well, but there are times where things happen. If clients have their money in a bank is when I see this a lot, instead of a direct express card. Sometimes things get garnished, or bank levies, garnishing from checks for employment money. But if you have only SSI in an account, only SSD in an account, it makes it much more clear. Once you start mingling funds is where the banks can sometimes get confused, and they may end up taking that money away if a landlord files a complaint in that DC court that we talked about earlier to try to get the money back. So landlords also, as far as fees, there are times where they can collect fees. For example, their attorney's fees, late fees, some of these things can be collected as well, but they have to be listed as additional rent in a lease. So if you have a lease that says that those things can be collected as additional rent, then the landlord can also attempt to evict for these fees. If there is no lease, or if there is nothing saying in the lease that these would be considered additional rent, then they can't collect. There are exceptions though. If there are, for example, Section 8 is the big one there, that this would be an example of when you can't collect these as additional rent. So there's a bunch of different exceptions, so you definitely want to consult someone for that to see if there's an exception for those items for the tenant. Okay, so for rent increases, if you have a lease and it's raising from year to year, the landlord does have to wait until the end of the lease and then have to send a notice saying they want to terminate the lease, and then give you the notice of the rent increase, saying how much the rent increase is, what the new rent's going to be, and things like that, and then propose to have a new lease. Month-to-month tenants, the landlord does still have to give 30 days notice before the rent increase can go into effect. Sometimes for month-to-month tenants, and I put this sometimes more here because sometimes for month-to-month or leases, if leases in particular, if the original lease states something along the lines of needing 60 days notice before terminating, the landlord technically frequently would have to also give 60 days notice before they terminate the lease. Potentially, if they propose that they're terminating and increase it, if they want you to give 60 days notice, they have to give 60 days notice, unless it's specified in the lease as something else. So you have to carefully read any leases you have. Rent control ordinances for different cities can also limit what the percentage of the increase is in a specific year. But if there's no rent control ordinance for the city that the tenant is in, then it still can't simply just be an unreasonably high amount. It has to be conscionable, it's called, or reasonable. It can't just be a limitless amount of percentage. So the landlord can't sit here and say, well, you know what, I'm going to raise it by another $1,000 for a lease that's $1,200 and $1,500. That's not reasonable. Just gonna have some water here. Okay. So rent. So again, as we talked about, the only remedy, the only thing that the landlords can seek in landlord tenant court is possession of the property. And again, examples of the additional rent that could be asked for as part of that eviction would be the attorney's fees, other costs. If you end early, sometimes there's costs for, AC units, for example, I've seen could be an additional cost that may be collected as rent. So but there could be different examples. It just depends on each individual lease. And again, there could be limits depending on federal, state, or local laws. So month-to-month tenants, no matter where they are, if they are in a home, like as long as they are covered in a home that's covered by the Anti-Eviction Act, like we talked about earlier, most places, as long as they're not owner occupied with two or less, like at least 2 units, or for example, the hotels, motels, those are not covered. But okay, if they are covered by the Anti-Eviction Act, month-to-month tenants still have the same rights as tenants that have a year lease. So it doesn't matter if you have an oral agreement that's still considered a type of lease, or a written lease. You still get the same protections under the Anti-Eviction Act. So if a landlord doesn't have a formal written lease, they can't simply turn to the tenant again. They can't turn to the tenant and say, you know what, okay, your month is up, I think 30 days and you're out. That's not how that works. You still have to go before the court. The judge, again, is the only person that can decide whether the tenant must leave. So this, even if it's an oral lease, it does automatically renew unless the landlord starts to try to say that there's a reason that the lease has to end. For example, some of the reasons, such as non-payment and everything we talked about before. So just to explain what a lease is in general, it's a contract. It's a specific agreement between a person or sometimes an entity, an LLC. Sometimes landlords don't have themselves as in charge, but they have an LLC as in charge of the property as the entity that owns the property. So either the person or the entity has the right to possess the home. That's who the landlord is. And then the other person as part of the contract would be the tenant, which is the person that has the right to use the property. So using the property and owning the property, that's who the contract is between. And as I said, it can be oral or written, but if it's as long as there's some sort of agreement as to what the monthly rent is, that creates an oral lease automatically. If you don't have it in writing, that's fine. As long as you have that, you still only have that once a year limit on increasing the rent. And in case you weren't sure, tenants are not really favored in leases. It's, all the leases are proposed by the landlord, they're going to favor the landlord. But just because the tenant might have rules, that doesn't mean that they can't just follow, reasonable guidance of public policy. They can't just create random rules that don't have a basis in something that's beneficial to public policy. So if you're going to have a rule that says, you can't smoke in the units and you can't smoke on the property, that's going to benefit everybody at the property, arguably. So that would be reasonable. You can limit smoking to not impact the health of others. So if there's a question about what one of these leases means, like one of the terms or the rules in the leases, the court is supposed to look at this and consider it in favor of the tenant because, again, so the tenant doesn't really have any bargaining power. When creating a lease, you can review your leases, highly recommend you review your leases and try to negotiate with the landlords, but that doesn't always mean they're going to negotiate. It's the court. The law takes that into consideration, and so anything that there's a question about what this term means or what this lease rule means, it's supposed to be construed in favor of the tenant. So most leases, like we talked about, are mostly for 1 year. And the tenancy, again, does not end at the end of the lease. It does continue automatically. And can move on as long as you stay. As long as you've given your notice. Sometimes, as I said before, it could be 60 days as required. It could be 30 days. You give notice that you're going to move and you do so properly, then you don't risk any request from the landlord to pay rent for a month that you weren't living there. So give your proper 30 days or 60 days notice, move out properly, take pictures of the property before and after you move out so you can make sure that you have proof of what the conditions of the property were when you moved in and what it was when you moved out. And then you should hopefully be good. Any questions for security deposits and what you get back, we're not really going to cover today, but if you have any questions, I'll hopefully have time at the end to talk about it. So, as I kind of mentioned before, if you're breaking the lease in the middle of it, sometimes there are reasons that you can break your lease. For example, here, as I've listed at the end here, certain reasons for disability or domestic violence may be a reason to break the lease. There could be other circumstances. Landlord could potentially try to go after the tenant for breaking a lease early and try to seek payment of anything that they would have gotten from the tenant, but they do have the obligation to try to cover that with getting a new renter themselves. So it's not very common for someone to need to break a lease in the middle of an initial term, but obviously the longer you stay, if you're renewing a lease, that is something that may happen. So you want to be careful about giving notice and documenting any reasons that may cause you to need to leave early. So here are some links as well to different manuals, I would say, that give a lot of information as well about landlord-tenant court and the process. This first one, the Truth in Renting Act, there's a publication there that is also another set of laws. The law directs DCA to give a whole summary of the rights and obligations in tenancies, and that can be found online as well. And it does prohibit the landlord from giving any lease provisions that are against New Jersey law. And then Legal Services in New Jersey also has a couple different sections for housing and an entire tenant's rights manual that is very helpful as well. And I do see some questions, and I will get to those at the end. Yes. So one of the reasons, again, that you could have a tenant being facing eviction is habitability. So there is an obligation for the tenant to take care of the property. And obviously, when you live in a place, there's going to be times where you bump a piece of furniture into the wall and next to the wall, and there's just a little, normal wear and tear. But anything that's beyond that normal wear and tear is something that is going to be a bigger deal. And so if, for example, a pipe burst, that's not the tenant's fault. That's something the landlord has to take care of. But if the tenant smacks furniture into the wall and the pipe bursts because of that, that's where, that's a little bit different. But generally speaking, things like that are not as common as a pipe just accidentally bursting, because houses are not perfect, apartments are not perfect. They break down over time. So this requirement, there is law on this, and the landlord does have this clear obligation to provide safe and sanitary housing. The issue that a lot of tenants struggle with, though, is that it doesn't necessarily mean that every single thing that doesn't look good has to be repaired. That is not the obligation, unfortunately, of the landlord. They do have to repair things that are vital. So if the toilet's not working, if you have no water, those are more serious issues. Just having maybe a section of paint that's smudged off after the first year is a bit different than having, not had an apartment painted for maybe 10 years, that these are a bit different. So it has to be taken into consideration. It's very kind of sensitive consideration for the different facts. So if you have any questions, again, you can call our office and we could evaluate the tenant specific case to see if it rises, if it meets the level that's needed to have one of these cases. So if the landlord is not providing the safe and sanitary housing that they're required to, the recourse that tenants have would first be to write a letter to the landlord saying, this is what's going on. This is, I'm giving you notice that I'm going to start withholding rent if you don't fix these issues. But again, they have to be those serious issues. And then you have to give them the opportunity. Today is October 18th, I believe, if I'm not mistaken. And so then they have until, let's say, for something that's a simple issue, 2 or 3 weeks, more complicated issue, maybe a little bit more, give them a bit of time to fix these issues. And then if the landlord's not doing so, maybe say by November 1st, depending on what the issue is, you could write in the letter, if you're getting it to them quickly and it's earlier in the month, maybe by the next month. But at this point, you might want to give them a bit more time and say, hey, but for December 1st, if you don't fix this, by December 1st, I may start withholding rent. And the tenant, if they're not seeing the landlord fix these issues by that time, they do also have the ability to repair the issue themselves. If it's obviously a pipe burst or something like that, and it's a couple days or weeks going by, that may be something that at that point they may want to consider talking to an attorney and seeing if they could repair it themselves and then deduct it from their rent. That's another option as well. Or they can simply start withholding the rent after sending that letter. The notice is really important. Without that notice, the court does not care if you had issues in the home that were super serious. If you didn't give that landlord the notice that there are the issues going on, you can't prove it by sending out that letter, sending it in the mail by certified mail so that you have the proof in the green card that you sent this to the landlord, and then you gave them time. If you give them 1 or 2 days to fix an issue that may take a week or more to fix, then that's not reasonable. But sometimes there are issues that are so serious that it's, going to be unhealthy for a tenant to live there. Sometimes maybe a fire, mold and bugs is obviously a major one as well. If it's so detrimental to your health, that may almost be an eviction as well, if they're not going to fix the issue or give you somewhere or some other recourse at that point. So again, come talk to us about that if there's any more questions about that. Again, as I said before, most of the issues that are listed in that first notice can be resolved if the tenants try to resolve them. If it's something sometimes where the landlords really just want somebody out, so they'll say that the issue was still happening, but it may, in that second notice, it may not be exactly the same issue as the first notice. That's sometimes where there is that wiggle room that we talked about that'll be important for trying to get the case dismissed or trying to settle with the landlord. Because if the notices aren't exactly clearly about the same issue, then those are 2 separate notices. The landlord should have then issued a new notice to cease, because you have to give 2 notices for many of the issues that we talked about. For example, like I said, a lot of other issues that we sometimes see are possibly hoarding, or just general uncleanliness. Maybe it's not quite to the hoarding level, but if some of these issues are written about in a notice to cease, you get a lot of time, and even after the complaint is filed, you still have some time to fix this issue. If the notices are sent and therefore assaulting another tenant or assaulting somebody, like the landlord, for example, that's not something you can really fix. So you don't get an opportunity to fix that. You just we're going to be brought into court immediately. So before I move on to the subsidized housing, if anybody has any questions about that, briefly, if you want to put them in the chat, I'll try to take a look at them while I get a sip of water. So I know that was a lot, but if anybody has any questions about the substance of it, let me know.
So far, Christina, there's a question if you're able to share your PowerPoint slide deck.
Yes, I did see that. I'm gonna double check. If I can, I will give it to you and I will let you know. But I know that these are recorded as they are, right? So I'm not sure how you normally get the recordings out.
Sure, we can connect about that later. Sure, thank you.
Yep.
Does anyone else have questions for Christina? You're welcome to place in the chat, or if you feel comfortable, you can unmute yourself.
I do have a lot more, so I am going to actually move on. But if we want to ask more questions at the end, hoping to get through this part a little bit more quickly. There's just a lot in housing to cover. So if you have questions, just put them in the chat for now, or if you want to ask at the end, I'll stay late. That's fine to do that, as long as it's not too late, because I know Amy's going to need to, sure, hop off too. So for getting vouchers, getting affordable subsidized housing, there are many programs. Most of them aren't even listed on here because some of them are not programs you can necessarily apply to just on your own. Some of them you may be connected to through agencies such as DDD, for example. There are vouchers that DDD has sometimes in certain situations. There are other types of vouchers for mental health and different things, and sometimes substance use disorder. So many of these vouchers aren't ones that you can apply to, but for those that are subsidized or affordable housing options that are application based, the main one that obviously everybody knows about is Section 8. There's Section 8 vouchers you can get through the state application. When their wait list opens, you apply to the wait list. You don't apply for the voucher itself. First, you apply to get on the wait list. It'll be a lottery system. And then if you get approved, if yours gets picked, you get put on that wait list. And then from there, eventually your time will come up. Sometimes different things will put you up higher on the wait list. For example, having a disability or having kids in the household. Things like this could put you higher up on the list potentially. And also being over a certain age could put you higher up on the list. So having a couple of these things would, possibly put you higher up on the list than having none. But besides the state application, there are different community programs or cities that administer some of these vouchers as well. There's also what's called an SREP voucher. You can go to social services and get TRA, the temporary rental assistance. That's like a temporary sort of kind of a band-aid in a sense until you can get more affordable housing at points. Or if you're on Section 8 or on their wait list, but something happens and you need some more rental assistance, sometimes this can help cover it. There's also emergency assistance, or EA, that is used towards shelter placements frequently, and sometimes you could use it for security deposits as well. And then for state options, there's also the public housing authorities. So a lot of cities have their own public housing authorities that will themselves either administer vouchers or they'll have these affordable housing options. We'll have public buildings in their cities. And some affordable housing options are just apartments owned by small landlords. Some landlords just keep their rent lower because they are aware of the different limitations that many people have in being able to afford housing. It's not very frequent, but there are landlords out there that do try to keep the rent low. And there sometimes are lists that may list these landlords on there and designate them as affordable. There's another quick program I want to make you aware of. It's called the Foster Youth Initiative. It is a housing choice voucher. A housing choice just means you get to choose where you want to live. You get to choose the apartment that you want to stay in. It's through HUD. 36 months of assistance only, and provides supportive services. It's kind of a program to cover the gap of people that have become adults and leaving foster care, to give them some sort of stability as they transition out of foster care and onto their own, and to become more independent. So you have to have a current or past history with DCP&P, and it has to be within that time frame of when you're leaving foster care, either that you have left or will leave within 90 days. And it's not every county that has this, so definitely check in with your county to see if this is a program, if you have a tenant that would fit that criteria, to see if that's something they offer. So Section 8, as I mentioned, they have their wait lists. They're open on that lottery system, and they do, that did not mean to go back, but they do pre-screen their tenants based on criminal histories and things of that nature. So that criteria is available on, it should be available on the PHA, which is the Public Housing Authority, on their website to be able to review what the criteria is. Criminal history is a major one of that. And so there are a bunch of different things that I mentioned you're going to run into. To start, when you get that Section 8 voucher, you're going to have a quick time limit. Starts at 60 days, and that's how long you have to find a unit within that range. And as I mentioned in the beginning, the range is very much behind at times, because HUD will update it, and they have been updating it more recently, but it is still not necessarily the rents that you're going to see out in all of the neighborhoods. So it might be in a different neighborhood that maybe you don't live in now, or maybe the programs that fair market rent is at kind of behind a year or so, and so it hasn't been updated, and the rents have increased drastically. That's a problem a lot of clients of mine have faced recently, and so that really does limit the ability of where you're looking and what type of apartment you can get, like what type of, if it's a bigger unit, if it's a smaller unit, how many bedrooms is what the fair market is set at. They do consider, you know, for 3 bedrooms, they'll give you more than they would give for 1, but that's not always in line, like I said, with the current rates, since it does take a while for HUD to update it. But if there are issues that cause you to need an extension of the voucher, you can ask for an extension, especially a reasonable accommodation. They'll give extensions sometimes as well without requesting a reasonable accommodation, so be aware of that. After you find an apartment, you have to meet the HUD housing quality standards. You have to pass inspection according to HUD's standards. And then the first year's rent has to be 30% of the income, but the total rent plus how much the utilities are estimated to cost can't be more than 40%. So that, as I said, is kind of where you can get into an issue of finding and getting a unit approved at times by Section 8. And then ongoing problems to look out for every year. The tenants are going to need to recertify. That means just they have to provide updated income information. And along the way, you have to provide updated income information. If you get a job, you have to let them know if your income changes in any way other than an annual increase in Social Security for cost of living adjustment. You don't have to update for that, but otherwise, you get any sort of change in income, you have to let them know. If you want to move out, you also have to go through Section 8 as well, so just be aware of that. If you do want to move on your Section 8 voucher, there is a term of a year about, in most cases, that you have to stay within the unit. And then after that, you could potentially move out at that point. If the property is not meeting the standards as well for that housing quality standard that I mentioned before, that could cause Section 8 to stop paying their rent. And then if they are waiting for the issues to be repaired, if there's broken window that they find and they say, landlord, you have to repair this. If it's not repaired after 6 months, or if it's 6 months of them not paying, then the contract with the landlord will end, and that could cause the tenant to have to leave as well. So there are different grounds for termination, which is separate than eviction. Termination of the Section 8 is when you lose your entire voucher. That can be really devastating. So it's really important to make sure that as a tenant or people that may work with tenants, you're kind of on top of making sure these are not going to impact the tenant. So you can get evicted from housing for a serious lease violation. So something that's more significant could lead to the termination of the entire voucher. Not following any administrative requirements, such as the recertification or reporting your income changes. If you don't establish your citizenship or immigration status, violating different family obligations that you are required to meet as a Section 8 voucher holder, or any criminal or drug-related activity, criminal activity specifically, that could cause it to get terminated, as well as failing to pay rent to the owner. So simply just failing to pay rent could cause you to have your Section 8 terminated as well. And as a reminder, if Section 8 is terminated, but you're not evicted from the property, that can really be a problem, because then you as a tenant could be taking on the full amount. So if it's $1,200 and Section 8 is paying the chunk of it, you could then become responsible for the full $1,200 as the tenant. So that's why it's very important not to get terminated, and to kind of be on top of that as well. So they have a whole process for terminating the voucher that's listed out here. There's a lot of specifics that you have to follow, but they change depending on what type of tenancy this is. If it's with different housing authorities, it may be different. So you have to review the different plans, but generally speaking, there should be a written notice that lists what happened, why the tenant's being evicted, and what their rights are. And there are different hearings that have to be conducted. It has to be kind of fair, in a sense, where people that were involved in the process can't be involved in the termination process. There has to be written decisions. It's very regimented. But the housing authority does continue to pay rent until tenants evicted. So even if there's an appeal that's going on, they still pay rent. So if an eviction is filed by the owner in landlord tenant court, they have to notify the housing authority. This is also something that can cause a case to get dismissed from court if the landlord has not done that and the tenant has a voucher. If they don't notify that housing authority, then that's a big deal for the case, and it can get dismissed. And the landlords can only evict on the Section 8, a Section 8 tenant or a family for grounds that are under the Anti-Eviction Act or other law. If it's an owner-occupied home, they still have to follow the same rules. So it's a public housing authority that is not itself dealing with Section 8 if it's just, let's say, a subsidized building. So the whole building has lower rent, for example. They themselves have different procedures. And again, you should look at any administrative plans that the housing authority has on their website. So they also have to provide termination, like written notice of the termination itself. They have to give you an informal conference, and there has to be a whole grievance proceeding. So the termination notice time frame is 14 days for non-payment of rent, 30 days, or possibly less, depending on what the state law says for other reasons. And the notices have to specify, as I said, the reason for the termination, and the given information about the right to the file and other rights for grievances that you have. And you have to file for the similar reasons of good cause, but they're a little bit different. So there still has to be a valid reason for terminating the voucher, or the terminating the tenant from receiving this public assistance. And similar for federally funded housing. So if it's funded by a federal agency instead, they still have to follow their own specific regulations. So again, these all have different areas of law that are covered. So it's very fact and law sensitive. So definitely seek an attorney to kind of sort all this out and figure out what the rules are, because they'll change depending on the program that you're under. And this is essentially the same thing, saying about the specific rules and what they have to, what has to be in the notice and the length of time of the notice. They're pretty similar, but slightly different for each of them, of how much they hold. And so, as I mentioned before, for a lot of these rules, you can request a reasonable accommodation or modification of the home if you need a modification of the home that you're staying in, or a modification of the rule, depending on which law you're referencing. Here's a quick overview, but I'm not going to discuss that today. But here's a quick bit of information if you want to seek that out on your own at another time. But so again, as we talked about before, best practices: get the lease, read through the lease, take pictures when you move in, make your rent payments on time, get receipts of your rent payments and your security deposit, keep your place clean, and give written notice when you leave, and take more pictures again when you leave. And as long as you do all that, hopefully everything should go smoothly. But if something happens where you do need some rental assistance in the meantime, to cover some of the rent, there are state and county programs. There is the Department of Community Affairs. It's called the Comprehensive Eviction Defense and Diversion Program. That's statewide. And there are what's called resource navigators, or navigators, that the court has access to, that can help you navigate the resources and find possible rental assistance out there in your county. And so with that, are there any questions that anybody has at this point?
I don't see anything in the chat right now, Christina. I think you were very thorough, so you probably answered a lot of questions people might have.
Yeah, it's a lot of information, and I know it's complicated, which again is 10 out of 10 why I recommend talking to an attorney about a lot of this stuff.
Yeah. Just another request for the slide, so we'll connect about that. Thanks so much, Walter. Well, that concludes the workshop for housing and tenant rights in New Jersey from Community Health Law Project. Thank you so much, Christina, for sharing your knowledge and resources with us today. It's truly appreciated.
I'm just going to put up our contact information again in case you need us or have any questions. If you don't have somebody that's in the Elizabeth area, we can direct you as needed to our different offices. But thank you guys.
Thank you.